The second thing I wanted to talk about was this case that popped up in the Fourth Circuit, where they say the judge fabricated an immigrant's appeal waiver, which kind of out of control. The judge at the immigration judge level with the EOIR didn't give any time for the person to talk or appeal, translate stuff, and essentially railroaded them into just being deported. And they appealed to the fourth. The fourth says, we conclude that this his 2011 removal hearing was fundamentally unfair. And that's Fourth Circuit coming to say that. That's excellent that they were paying attention to that. But it's so cruel that the judge was just just pushed him aside like this. Um, so they say it's quote, it is easy to see why, if the government's reading held sway, the non-citizen will be stuck in a classic catch-22, live with the immigration judge's order, and therefore be prevented from seeking voluntary departure, or attempt to appeal to error and foreclosure ability to seek voluntary departure anyway, the decision said. The voluntary departure regulation's plain text does not require such a Kafkaesque result. In fact, it commands the opposite. So, a real weird show. There might be a good case law to follow forth and other people look into. The case name is, where is the name? US v. Bonifacio Fernandez Sanchez. So US v. Sanchez. I mean, there's probably 1,000 US v. Sanchez's, but case number 20-4061, US Court of Appeals, Fourth Circuit. Congrats to the attorney team. Sanchez represented by Erin Margaret Trodden of the Office of the Federal Public Defender. Well, God bless them. Doing some good work there.